The high courts are the highest courts in a state, and every high court consists of a chief justice and other judges, just like the Supreme Court. As per Article 215, every high court is a court of record, which means they can punish any person who is in contempt of court. A retired judge of a high court is permitted to continue to practice as an advocate at the Supreme Court or any other high court. Article 214 states that each state shall have its own high court. However, the Parliament can establish a common high court for 2 or more states, or for 2 or more states and a union territory as well. For example, the High Court of Kerala is common for the state of Kerala and the union territory of Lakshadweep. The High Court of Calcutta is common for the state of West Bengal and Andaman and Nicobar Islands, etc. As far as the qualifications are concerned to be the Chief Justice of a High Court, firstly, they should be a citizen of India, and secondly, should have held judicial office for at least 10 years in India, or should have practiced as an advocate of a high court for at least 10 years. With regards to appointment, term of office, and removal, the following points shall be noted. Firstly, as per Article 216, all the judges of a high court are appointed by the President after consultation with the Chief Justice of India, the Governor of the state, and the Chief Justice of the High Court. Secondly, each judge shall hold office till the age of 62 years. Thirdly, a judge can resign from his office by giving a letter in writing to the President. Fourthly, Article 217 provides for the removal of a High Court judge. A judge can be removed from the office on ground of proved misbehavior or incapacity. And lastly, he can be removed only by an order of the President passed after an address by each House of Parliament, supported by a majority of total membership of the House and by a 2/3 majority of the members present and voting, just like the Supreme Court. Now, we'll take a look at the powers and jurisdiction of the High Courts. Firstly, we'll talk about original jurisdiction. Every High Court has original jurisdiction in revenue matters as under Article 225, as well as in matters relating to admiralty, matrimony, probate, contempt of court, and extends to hearing of election petitions as well. The High Courts of Calcutta, Bombay, and Madras have original jurisdiction in civil cases of certain monetary value and criminal matters as well. Secondly, we'll look at appellate jurisdiction of High Courts. Well, all High Courts hear civil and criminal appeals from subordinate courts under their control. In civil matters, the High Court has jurisdiction to entertain appeals from any judgment or order of the District Court, and in criminal matters, it has jurisdiction to entertain appeals from judgments of the Sessions Court. Thirdly, we'll be looking at writ jurisdiction as mentioned under Article 226 of the Constitution. The High Courts have the power to issue writs not only for the enforcement of a fundamental right, but also for other constitutional or legal rights. This makes the writ jurisdiction of the High Courts wider than that of the Supreme Court. The High Court has the power to issue directions, orders, or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari. Fourthly, we'll be looking at supervisory jurisdiction of the High Courts. The High Courts control and supervise the working of the courts subordinate to them and frame rules and regulations for them to carry their day-to-day business. Under Article 227, every High Court has superintendence over all courts and tribunals located in their jurisdiction. It can relate the practice and proceedings of these courts. Fifthly, there are certain inherent powers that the High Courts also have as per Section 482 of the CRPC. The Code of Criminal Procedure saves the inherent powers of the High Court in criminal matters. The High Courts have wide powers when exercising jurisdiction under this provision. However, this jurisdiction has to be exercised in a limited manner. Now, let us take a look at the subordinate courts. As mentioned above, there are subordinate courts under the high courts in each state. A class of courts is established to deal with civil matters while another is established to deal with criminal matters. The district court is the highest court of civil jurisdiction, whereas sessions court is the highest court of criminal jurisdiction in a district. In addition to those mentioned above, certain special courts are also established to deal with specific cases. For example, family court is established to deal with matters of custody of children, appointment of guardians, divorce, etc. Rent control courts are established to resolve the disputes between landlords and tenants, and so on and so forth. Then there are tribunals too. Part 14A of the Constitution deals with tribunals. It was added by the 42nd Amendment in 1976. The Parliament is vested with the power to establish tribunals to deal with the disputes regarding public appointments, tax, foreign exchange, recovery of debts, etc. Examples of some of these tribunals include the Central Administrative Tribunal for Service, Debt Recovery Tribunal for Debt, National Company Law Tribunal for Corporate Matters, etc. All these tribunals are established by the Parliament by passing specific legislations for their establishment. Lastly, we have something called quasi-judicial bodies as well. A quasi-judicial body is a non-judicial body that can exercise certain functions of a judicial body. It does not possess all the powers of a court but has certain powers which are limited in scope. The adjudicating body usually consists of a person knowledgeable in law and one or more experts in the respective field. For example, the National Consumer Disputes Redressal Commission is a quasi-judicial body which exercises powers vested under the Consumers Protection Act and resolves disputes between a consumer and a seller or service provider. The members of the commission consist of a sitting or retired judge of the Supreme Court and at least 4 other members who are experts in the field of economics, law, commerce, accountancy, industry, public affairs, or administration. With this, we have covered all the different kinds of judicial bodies, starting from higher judiciary to lower judiciary, from special courts to tribunals and quasi-judicial bodies, their powers and scope. With this, we have come to the end of this video. Hope you have a clearer idea about the Indian judiciary now. Have a good day, take care, and all the best.